This is the brief on the New York Times lawsuit against Microsoft and OpenAI. The New York Times has intensified its legal battle against Microsoft and OpenAI, setting up a landmark clash that could dictate the future of how artificial intelligence models are trained. First, the updated accusation. Following a recent Supreme Court decision regarding contributory copyright infringement, the NYT argues Microsoft isn't just a passive cloud provider. They say Microsoft actively built a custom supercomputer specifically to train OpenAI's models using massive amounts of copyrighted NYT content. So, the NYT is arguing that Microsoft isn't just the landlord renting out server space, they actively helped build the machine that allegedly copied the data. Second, we have damages versus fair use. The NYT claims ChatGPT reproduces near-exact excerpts of their journalism, reducing subscription incentives, and that it hallucinates fake news attributed to the Times, heavily damaging their credibility. In response, Microsoft and OpenAI rely on the fair use doctrine, arguing that training AI on publicly available internet data is a legally protected standard practice. This begs a journalistic question: does an AI system digesting a public article legally count as fair use, or is it simply high-tech plagiarism? Finally, consider the industry-wide stakes. If the courts rule that this training violates copyright, it could upend the entire generative AI industry. Conversely, if the tech giants win, it legally solidifies the practice of training models on massive volumes of internet content. How does the law strike a balance between rapid technological innovation and the protection of creators' rights? Ultimately, the resolution of this single lawsuit will draw the legal boundaries for the entire artificial intelligence industry for years to come. You can read more about it at www.robota.ai.com.br. We're about to see if the courts can actually keep up with the tech.